Record. Very good. I see both counsel, Mr. Showers representing the appellant. You are all set, so you may proceed when ready.
May it please the court, good morning.
Morning.
I am here on behalf of Ronald McGee. He is the personal representative of the estate of Quan McGee, a minor child decedent. This particular suit is against the appellee, Eckert Youth Services. The appellee, Eckert, filed a motion for final summary judgment pursuant to Florida Rules Civil Procedure 1.10. In opposition, the appellant argued that there were material facts in dispute of which would support the wrongful death claim.
Mr. Showers, do you want to reserve any time for rebuttal?
Oh, I'm sorry. Yes, please. 5 minutes. That's fine.
Very good. So let me ask you a question now that I've interrupted your flow. The statute that is involved in the case has some protections for agencies and for organizations like Eckerd that are the lead organizations. And much of the argument presented by Eckerd revolves around that statute. So my first question is, if the lead agency isn't liable in tort for the acts or omissions of subcontractors, officers, agents, or employees of its subcontractors, what evidence was presented that Ms. Blossom was an employee or agent directly of Eckerd, which appears from the record to be the lead agency?
Your Honor, we did take her deposition, and she clearly stated that she was an agent of Eckerd. I don't think there was any dispute that she was an agent and or / employee of Eckerd College. I'm sorry, Eckerd. They actually provided the training for her. They did the background checks for the Blossoms, and that I don't believe that was in. I don't think that was in dispute as to whether she was an agent of Eckerd. All
right, so your position is that issue, to the extent it's an issue, is disposed of by her deposition?
Yes, Your Honor.
Okay. And so then we get to really what I think is the crux of this, which is what negligence, and we know there was some event that took place that resulted in the death of this child. And we know it had to do with placement on the bed. It seems those are undisputed facts. So tell us how we get to Eckerd if there is no specific pleading of vicarious liability as to Eckerd.
Good question, Your Honor. I guess the respondent superior was not. It was not pled in the complaint. However, there, I think, in the, at least what we believe in review of the entire complaint, the notion of respondent superior was clearly pled with the allegations that she was an employee / agent of Eckerd, They provided training. They were the provided supervision also. And as previously stated, they were the lead agency. So even though that the I guess the term respondent superior was not specifically named in the complaint, there's we feel as though that there was sufficient existence of the notion of respondent superior.
What, can I ask you a question?
Yes. Oh,
I interrupt? I don't want to interrupt, but what's the
No.
connection between the conduct of the Blossoms and the training of Eckerd? What did Eckerd do wrong that led to this infant's death? And what did the people do wrong other than put the baby in the bed, the toddler? And I assume they're not part of this appeal, and were they joined below and resolve this matter, or what's the status of the Blossoms connection?
okay, to answer the first part, they were not joined in this particular appeal. But as an agent or an employee of Eckerd, they basically, the Blossoms had the duty to provide the safety and welfare of that particular child. And unfortunately, in their duty as caregivers for baby McGee, I mean, they were negligent, and unfortunately, it led to the death.
I just want to understand. You're not saying this is SIDS. You're saying failure to supervise, the breach of duty. You're not saying strict liability. You're saying whatever it takes to keep this case alive, essentially.
Yes, I mean, I'm not right. I'm not saying strict liability. No.
Okay, all right. That's all. Thank you.
Let
Mr.
me ask
Towers,
you a
I'm-
question. Go ahead, Judge
Judge.
Silver.
No, go ahead.
So my question is this. Your friend on the other side has argued that Miss Blossoms, and it was tragic, you know, she made this admission that she made a mistake. She's never done it before. She knows it was wrong. And she, I think in more than one way, took full responsibility for her conduct, which she admitted was not consistent with the training that Eckerd had given her. And your opponent has, of course, argued that this renders the plaintiff unable to prove causation as to Eckerd. Help me out with that, because I think that's a big legal problem for you here with that.
I'm sorry.
admission.
Can you repeat that, Your Honor?
Yeah, Miss Blossom made an unqualified admission that this was solely her responsibility, that putting the baby in the bed as opposed to the crib or the pack and play was contrary to the training and instruction she had received from Eckerd, and that it was solely her fault. She obviously feels terrible about it, but she did accept full responsibility, and she admitted that it was not consistent with how she'd been trained, and she knew it was wrong. So your opponent has argued that that defeats the plaintiff's ability to prove causation. And what I need to hear about from you is why he's wrong on that, because I think that's a legal hurdle that you need to scale.
Yes. Miss Blossom, I mean, during her deposition, she did admit to wrongdoing. However, I mean, she was still, I mean, she was an employee or agent of Eckerd. And I guess in administration of her duties, administration of her training, it caused the death of this, of baby McGee.
But sorry, let me put the question to you a different way.
Okay.
If she admits that she didn't follow the training that Eckerd provided, so how could Eckerd possibly have prevented this?
Well, um, hmm. I guess the things, I mean, it's a negligence action. Um, and I guess the way that I will try and present this, or at least respond to your question. If I have, I guess if there's a parent, the parent, and hopefully this is not too comical. The parent has children. Once that child reaches a certain age, that child wants to operate a motor vehicle or drive. So that parent goes out and trains, or at least teaches the kid how to drive, teaches the kid as far as the rules and regulations of the road. It is I think it's reasonable to say that there's the possibility that that child could be negligent in the operation of that particular vehicle.
But isn't that based on speculation? Because the question becomes, was the training deficient? And it seems that the evidence in this record is the training wasn't deficient.
I guess it's unfortunately, I guess I'm not disputing as to whether the training was sufficient or
But the
not.
argument you just made, Mr. Showers, the argument you just made was based on some problem with training. And my understanding is you really didn't, I should say, the plaintiff didn't pursue that avenue in opposition to summary judgment.
Well, I think during I guess as far as discovery and trying to at least doing the discovery for this particular cause of action, the issue was, I mean, it came down to the training. Obviously, the Mrs. Blossom, failed to use due care in at least providing the safety and welfare of baby McGee. Obviously, she indicated that she did have training as to where to place the child when the child is to be laid down for napping. However, I mean, unfortunately, she did not.
Was there any evidence that Eckerd failed to provide proper training to Ms. Blossom?
No,
Or
Your
are
Honor.
you simply relying, you're simply relying on the result of what she did as opposed to there was some actual deficiency in the training provided to her?
That's correct, Your Honor. Yes.
Okay, and let me ask one other question. I want to go back to the agency issue because I just looked at the complaint again and I don't see a specific allegation that Ms. Blossom was the agent of Eckerd. There is an allegation that Lutheran was the agent of Eckerd. So am I misreading the complaint? Is there some allegation specifically that Blossom was the agent of Eckerd?
Well, I guess in review of the third amended complaint, as in the, I guess in the one moment, Your Honor, just let me. I believe I state in the factual background, I do discuss the fact that the Blossoms were agents and or employees of Eckerd College. And also
Tell me where in the complaint that is.
it is I think in paragraph number 15.
Blossom was licensed and or supervised by defendant Eckert and or defendant Lutheran.
Yes,
So it's not a specific allegation that she was an agent or employee of Eckert, because at best you have and or supervised by Eckert and or defendant Lutheran. So that's, I'm not quite certain that is adequate, but let's get beyond that, because in the trial court's order, the court specifically found that there was no evidence to support the idea that Blossom was directly an agent of Eckert. And you actually asked the court, are you going to address the agency aspect? And the court then said that. And I don't see any response saying, Judge, here's the evidence that established she was an agent. And Mr. Sheriff, I'll just let you know, you have 1 minute to get into your 5-minute rebuttal time. You're free to use it as you wish.
I'll continue to try and respond to your question, Your Honor.
If you're looking for the transcript, it's
No.
It's in
I mean, I guess I was going back to my to the complaint, and I do see, starting with the count 1 involving the appellee Eckert, and I go on to say that the defendant Eckert, as the lead agent, has a duty to protect safety. And if we go down further,
let's assume for the sake of argument,
yes,
that's enough of an allegation. It is not a sworn complaint. So
No.
when the court said there's no evidence of agency, it doesn't appear you pointed to any, either in your response to the motion for summary judgment or in response to the court's statement. So if you want to reserve, you now have 4 minutes for rebuttal. If you want to reserve that, and when you come up on rebuttal, if you can do that, that will be helpful.
yes, I will reserve the 4 minutes, Your Honor. Thank you.
Thank you. Mr.
Good morning, Your Honors. May it please the court. Jason Azarone on behalf of Eckert Youth Alternatives Incorporated. Your Honor's questions really demonstrate today the understanding by the court of the correctness of the lower court's granting of summary judgment in this case. I want to start with Your Honor's question regarding the pleadings in this case. There are no pleadings with respect to respondent superior or vicarious liability. And in my brief, I pointed this out. If we look at record pages 216 to 217, and specifically the allegations, and I'm sorry to be looking away from the camera, but I'm reading here. The plaintiff alleges that the defendant, through its employees or agents, breached its duty by, and then we have 4 separate allegations. Failure to use reasonable care to supervise, negligent licensing, negligently failing to train and conduct background investigations. Though none of those are activities that Mr. or Mrs. Blossom would have taken part in. And this was brought up at the hearing on the summary judgment, because respondent superior was brought up for the first time at that point. And I think Judge Silverman, the point of the transcript that you're looking for was right at the end, when the trial court said it really wasn't explored, it wasn't presented well enough, and there was no evidence of agency. So right from the beginning of this panel's questions, we're looking at where's the allegation, and it simply just does not exist. And the trial court correctly found that in granting summary judgment. That's why we can't get to the crux of this case. That's why we can't get from how is the negligence of Mrs. Blossom, and to call it negligence in the legal sense, it was, but as she fully admitted, it was a mistake. It was a lapse of judgment. And there is simply no connection between that lapse of judgment and.
Let me ask you a question as
Yes,
to
ma'am.
something that troubles me on your side of this, in terms of factual disputes. There was a post-incident inspection, and I don't remember the name of the person who filed the report, but it detailed that the bedroom, the bed, the bedroom, the surrounding area was not consistent with what generally I think was expected under the standards and the training that Eckerd provided. Did that create any sort of issue of fact with respect to, you know, Ms. Blossom very candidly apologized and accepted responsibility for this and said it was a one-time thing? And, you know, you heard the flip side of this question I asked your opponent, but I'd just like you to address whether that aspect of this record creates a fact issue that we need to be considering.
Well, and I'll answer that in two ways, Your Honor. Number one, it wasn't argued. I know that counsel put the DCF record in his argument, in his motion, and attached it. But at the hearing on the summary judgment, it wasn't brought up at all. Now, I will point out that
Well,
counsel,
can I add to that? Wasn't there a concession that the proper training, et cetera, did occur?
that was going to be my next point. Yes, Your
Sorry,
Honor.
well, I didn't mean to. I'm clairvoyant. Sorry about that.
You and I are on the same page, sir. It was conceded. Training, you know, we've had a lot of discussions here today about training and about the licensing and the background checks, but plaintiff's counsel conceded that all of that was correct. So what this really boiled down to was a supervision claim. That was brought out in all of the pleadings, and I brought that out in my answer brief. The other thing we have to remember, Your Honor, but more pointed to your question, I don't remember from the record, I'd have to go back and look, when that DCF inspection was conducted. However, remember, there was a guardian ad litem in the home the day of the incident, the morning of the child's death. And the guardian ad litem testified clearly, I was in the house, I went to the room, I saw everything. There was nothing that would have required me
And
to,
I read the guardian ad litem's report, and that was sort of where I realized the record was murky on, at best, I think, on the post-incident report. But that was what I wanted. That was where I was curious if everything was perfect the morning of, and shortly after it wasn't.
right. And you don't know what happened. I mean, you don't know what happened to make it, presuming there was testimony as to what that room looked like other than outside of that report. You know, plaintiffs can, again, does it create an issue of fact? I would argue to this court that it doesn't, because plaintiffs counsel had the ability to discuss those discrepancies with Ms. Blossom and chose not to. So to come in and just present argument, well, this creates an issue of fact. This court is aware that arguments of counsel can't do that. You need evidence, and there just simply was no evidence. And Judge Valenti kind of brings me back to where I wanted to go here. There's been a lot of talk today about training and negligent training, but again, that was all conceded that everything was proper in this case. So what we're really left with is a supervision claim. But even taking it aside, let's presume for a moment that negligent training is on the table and negligent supervision is on the table. This panel asked, what could Eckerd have done? What could have been done? And the simple answer is nothing short of 24/7 observation by Eckerd. And that's just not reasonable. It's not reasonable to expect Eckerd as the lead agency to be doing that. And it wasn't reasonable for Lutheran also. And that's why summary judgment was granted in its favor as well. At the end of the day, in this case, we are under the summary judgment standard that the plaintiff is required to present evidence, not just argument. And that wasn't done in this case. The lower court recognized that, and the lower court properly granted summary judgment. And we would ask that that order not be disturbed on appeal. Thank you very much. If there are no further questions.
Very good, Mr. Azarone. Mr. Showers?
Yeah, and I guess I go back to the inference as far as the concession with the training. There was no dispute as to whether Ms. Blossoms or the Blossom were trained as caregivers. I mean, I can't dispute. I mean, there was nothing presented or discovered to show that that she wasn't trained or she and her husband were not trained. However, I guess that still doesn't things happen. And I mean, that's one of the reasons that I think we have negligence actions. You can have all of the greatest training in the world, but unfortunately, as humans, mistakes are made. And unfortunately, in this particular situation, a child lost his life. And
Mr. Showers, I have a question. Were
Yes.
were you the trial attorney in this case?
I was, Your Honor.
Well, you deserve to be commended for your concession, because when you uncovered no evidence of negligent training or inadequate training, etc., you made that concession. Most attorneys probably wouldn't, but we'd still be in the same place. We'd still be arguing the same standard on appeal. So you deserve some kudos on this case, even though it's a tough, heart-wrenching case.
It was. And also, I guess, to further that, I mean, it's the opposing counsel mentioned that that Eckert can't be there 24/7. I mean, that goes back to the analogy as a parent. A parent can't be with that child operating that vehicle 24/7. Unfortunately, accidents do happen. And if something were to happen, that parent could be liable for the negligence of that particular child. And with that said, Your Honor, I believe that it's necessary to allow, I guess, a jury of peers to fully address this particular matter in this case. Thank you.
Very good. Thank you both.